Office. I call the Honourable Minister Judith Collins.
Mr Chair, thank you very much for the opportunity to speak on this bill at the committee stages. First, I would like to thank the members who have spoken on this part, Mr Chevelle and the Honourable David Parker. They've been good contributions. I'd like to thank them for the work they've been doing to try and get as much agreement as we can on this. There's a couple of issues that have been raised by them. Mr Chevelle's raised an issue around the safety or security, really, of documents that have been seized by police under a warrant where a claim of privilege has been raised. And there's been some concern that once the documents are in possession of the police or the court, they're effectively disclosed. Well, I don't agree with that. The police or other agency must not search the thing secured, and that's in clause 139C. That's in the bill itself. And the courts are generally trusted with highly sensitive matters on a very regular basis. For example, with details that are suppressed. If we don't trust our courts with this information, then we'd be in a very sorry state. I'm pleased to say that we do trust the courts. In all cases, a hearing would be held to determine whether the claim of privilege should be upheld. If it's not upheld, the police or other agency could use the document or computer file containing the name, or the journalist would be required to tell the police the name in the case of an examination order. If the police or other agency did search the document computer file, this would itself be a breach of the law. And of course, as we know with electronic footprints, it's pretty easy to tell these days exactly who's been looking and what and where things have come from. And I believe very much that would be disclosed. In addition, it's an offence under the bill to disclose information acquired in the exercise of a search or surveillance power, production order or examination order other than the course of a person's duties, functions or powers. There are also other avenues of redress, including complaints to the IPCA, the Independent Police Conduct Authority, and police also conduct internal investigations where officers breach procedure. For many officers, if they undertook that work, they would, in fact, essentially lose their jobs. So I don't think that we should think that police officers can't comply with the law. In fact, they do all the time. Another issue that the Honourable David Parker's raised, and I think it's a valid issue, and that's around the Serious Fraud Office, and I'm happy to address that. There's a couple of issues here. He wrote, as he's told us before, to the former Minister about the Serious Fraud Office, and he wanted the Serious Fraud Office included in this bill. One of the issues with that is that the Serious Fraud Office has never been included in this bill, which means that, and I understand the reason why, which is that the Labour Party was committed to merging the Serious Fraud Office or bringing it into part of the police. So, in fact, it would then become part under what would take over it would actually receive the powers under this bill when it went through. But let's be frank here, this bill's been hanging around since 2007. It's been a long time. This government's been quite committed to the bill, and we're now in year 4 of the term. If we had in fact waited for this bill to come into force and got rid of the Serious Fraud Office, as the Labour Party wanted us to do, we would have had 3 or 4 years in this case, waiting for some of these powers to be available for the police. So we would have had actually police not being able to undertake examination orders or production orders, and if the Serious Fraud Office wasn't there, they wouldn't have been doing it either at the very time when we've had disclosed some of the worst financial crimes that we have seen since the 1980s. So I think really to say get rid of the Serious Fraud Office at that time was somewhat premature, given that the search and surveillance legislation and the production orders and examination orders regime wasn't actually in place. So I understand what they're doing, and there's a lot of logic in what they're saying, but it's about having things in the right order, and it would have meant that we would have not had that power available to police. And the other issue is that they've raised is, well, why can't I bring it in now? And bring the Serious Fraud Office in now? Well, for a start, I actually think process is relatively important on things like this. The Serious Fraud Office has never been part of the bill, therefore it's never actually, the public have never been asked to submit on whether or not the Serious Fraud Office should be under this regime, or whether, Mr Chair,
I call the Honourable Minister, Judith Collins.
or whether or not it should remain with the powers it has since it's had since 1990. And I think to suddenly at this late stage, and I acknowledge that the Honourable David Parker wrote to my predecessor about this, to come, well, and the member says a year and a half ago, but I'd also say to the member, follow it up. Oh, right. Well, anyway, yes. Well, since I've been in, haven't you? I think it is fair to say, though, that at this late stage, and as the new minister, I'm not prepared to overnight or even over a month decide to change the powers of the Serious Fraud Office without that matter having first gone to a select committee. And it's the sort of thing where we've discussed what we should do with the Serious Fraud Office over the powers. We've had allegations made, and I think we've heard those around alleged misuse of the powers by the Serious Fraud Office, and the only example given to me was when the Serious Fraud Office gave production orders or served production orders on the National Business Review once last year. And I say is that just on that one issue, I don't think we should be completely changing the law that's been there in place since 1990, and which, by the way, was brought in by a then Labour government to deal exactly with the same issue that we've just dealt with over the last few years, which is massive financial crimes which were discovered as a result of the financial meltdown in the 1980s. Let's not kid ourselves. These crimes were happening before. They were simply discovered, and the discovery really came about because there was, in fact, a run on money, and therefore they got discovered. We've also now got the Financial Markets Authority in place, which I think is doing a far better job than its predecessor, the Securities Commission. So we do know we have some better processes in place, but I don't think it is right to come along, for me, to make a decision to say rein in the powers of the Serious Fraud Office without some serious debate in public in a select committee. The other issue is that in relation to those Serious Fraud Office powers is that they are very, very refined in terms of who they actually serve them on. These are the orders on. We're not talking about everybody who has contact with the New Zealand Police. We're talking about a very select group of people. And I believe that the same reason that these powers were brought in the first place is still there now, the same need. But also production order is, in fact, essentially a bit like a search warrant, except that instead of having a police officer charging through, looking at everything that you've got in your property, in fact, they ask you for what it is that you have. So in other words, it might be something like, I want these reports from this, this, this. That's a whole lot different and a lot less onerous for anyone subject to it than actually a full search warrant where everything can be looked at. So I think just because lots of the public don't know that there are production examination orders, that doesn't mean to say that they necessarily are very scary and difficult things. It's simply that most people, thankfully, have never had to be subject to them because they're not the people that the Serious Fraud Office is after.
I call the Honourable Member David Clendon.
Thank you, Mr Chair. Mr Chair, I'd like to take a call just to